So as we are running a little bit past schedule, I will try to be fairly efficient in doing my presentation. Actually, many of the things that I will discuss this morning has already been touched upon, so I can go through this quickly. But what I would like to start with is to show you a quick video. We can just start with that. Which summarize what I will be going through with you today.
The European Economic Area, the EEA, brings together the European Union and Iceland, Liechtenstein and Norway in the internal market. The EEA agreement is dynamic and continuously updated to ensure common rules for the free movement of goods, capital, services and people across the EEA. How does EU law take effect in the three EFTA states, Iceland, Liechtenstein and Norway? Experts from the three EFTA states contribute to shaping EU legislation before it is adopted by the EU. For instance, they participate in meetings of EU expert groups and committees. They also submit common positions to the EU institutions. When the EU adopts an act, the three EFTA states assess its relevance for the EEA and then request the EFTA Secretariat to draft a decision to incorporate it into the agreement. In this decision, the EU Act may need to be adjusted to fit the EEA agreement, for example, to ensure EFTA participation in an EU agency. Other adjustments reflect specific situations of the three EFTA states, such as geography or infrastructure. Each of the three EFTA states has its own national procedure to prepare for incorporation and implementation of an EU Act. When the three EFTA states have agreed on the content of the decision, it is sent to the EU Commission's Secretariat General. The Secretariat General and EFTA Secretariat coordinate the discussions between the EU and the three EFTA states on the final text of the decision. Once the draft decision is ready, it is sent to the EEA Joint Committee for adoption. This committee meets around 8 times per year and is composed of the ambassadors of the three EFTA states and officials from the Commission's Secretariat General. It takes the formal decision to incorporate the EU Act into the agreement. Joint committee decisions normally enter into force 1 day after adoption. If a decision requires amendments to national law, the parliaments of the three EFTA states must approve it before it can enter into force. EU law that has become EEA law must be made part of the national law of Iceland, Liechtenstein and Norway. The EEA, extending the EU internal market to Iceland, Liechtenstein and Norway. If you want to know more about how EU law becomes EEA law, please visit our website.
Was pointed out in the video, we have a lot of wealth of information on our website. We have a specific web tool that explains what I will go through today in much more detail. We are in the process of upgrading this, but to get into the presentation, we have let's start with the first slide. We have divided this into 8. Do
you see the arrow?
Doesn't seem to be. It seems to be quite small. So we have. I will just, while we try to find a solution to that, I will just continue. We have in this presentation divided this process into 8 different stages. The first. You can see how the outline of these 8 different states is done. The first one is the states when the, I can use this, okay, fantastic, is the decision shaping. And I think that we've already touched upon that, so I'm not going to go into much of the detail on that. But the key issue here is that the agreement ensures that experts from the EFTA states have the ability to participate in expert groups and committees on the EU side where discussion takes place on the formulation of proposal for new EU legislation. We also have the ability to send, we've developed our own an instrument called EFTA Commons, which allows us to send the comments from to proposal from the EFTA states. And that is beyond this participation in the expert groups and committees. Once the EU kind of have adopted this proposal, the decision kind of procedure within the EU start to take place, whether this is an act that is adopted by the Commission solely, if it's the delegated or implementing act, or if it's a act that requires a decision or adoption by the Parliament or Council, then the EU's internal rules on of course apply. But once those have been finalized, the final stage in the EU's procedure is publication in the official journal. And Nicholas von Lincoln already referred to that such acts may be marked in the official journal as being EEA relevant. And this is a very important piece of information because it demonstrates the position of the EU side whether an act is relevant or not, but it has no direct legal effect. I will have to emphasize that. And there are cases where a text with there's an act that doesn't have that is actually EEA relevant, but there are also examples of acts that are not EEA relevant that would have that text. So a very important piece of information, but doesn't have the legal implication. The fact that this is marked with EEA relevant doesn't mean that it's already part of the agreement. We need to follow all these steps that I will go through. When the EU has published an act, the first step after that is the EFTA Secretariat monitors all acts adopted by the EU and identifies acts that may be relevant for the agreement, and also conducts the preliminary assessment whether there might be a need for adaptation. And these are two kind of very important elements, assessment of EEA relevance and then the assessment of there is a need for adaptation. EEA relevance really refers to if an act relates to the scope of the EEA agreement. And as has been kind of discussed already, the EEA agreement really is an instrument that connects the EFTA states to the EU's internal market. So legislation that relates to the internal market would in most cases be considered EEA relevance. But legislation that concern other policy areas of the EU, for example, agriculture, the common trade policy, etc., is not relevant for the agreement. I will touch a little bit later on adaptation, but then a very important another element at this point, when the Secretariat is making this preliminary assessment, is to decide what kind of a procedure to follow on the incorporation. And there you essentially have a choice between what is called a fast-track procedure and a standard procedure. In any case, which track you use or procedure, sorry, we will send out information sheet to the experts in the EEA capital if it is the secretary assessment that that the fast-track procedure is appropriate. We send a so-called a fast-track procedure form. But if it's our assessment that the standard procedure form should be used, we used a different kind of form. After we have sent this out to the experts in the EFTA states, they assess the act and they make their own assessment of these two key questions that I referred to. Is it relevant to the EEA agreement? And are adaptations needed? And the video explained a little bit what are the essential for adaptations. We will have an excellent presentation in the afternoon on kind of how to read acts that have been incorporated in view of the adaptation. So I will not go so much now into the specific types, different types of adaptations. But I might mention here that one of the way to distinguish between adaptations is between technical adaptations and substantive adaptation. And Nicholas von Lincoln has already actually kind of referred to this. This is really a question of whether the EU can or the Commission can agree to incorporate acts in the agreement by itself, or it needs to consult the Council. If there are substantive adaptations, it will have to revert a draft decision of the EEA Joint Committee to the Council. But if adaptations are only technical, it has the mandate to decide on incorporation by itself. It's also important that the EFTA states, all of them have different national procedure on how they make this assessment on these kind of key issues that I mentioned, EEA relevance and adaptations, and how to how to respond to these forms that we have mentioned, and that is of course kind of laid out in the administrative guidelines of all the 3 EFTA states, how the decision-making procedures are for them to assess these issues. But once they have gone through their own national procedure in assessing a legal act, they send out the information. If it's a standard format, a standard procedure that is used. If it's the fast track, it doesn't really require any formal reply from them. But in any case, if the Secretariat considers our act to be appropriate for fast track, but any of the EFTA country may not agree, they can always object to it, and then the standard procedure will be followed. Once the EFTA states have made this assessment following their own procedures, the Secretariat can start the next phase, which is drafting a draft decision of the EEA Joint Committee. The Secretariat does this drafting based on the feedback that we have received from the experts of the EFTA states. Once we have drafted it, we send it back to the EFTA states for their approval. And once we have received approval from the EFTA states, both in the so-called working groups where you have the experts involved, but also in subcommittees 1 to 4 of the EFTA Standing Committee, which is usually the representative of the Foreign Ministry of the EFTA states, we are ready to submit it to the General Secretariat. At this point, the EU then reviews the draft decision, and this is done by launching a so-called inter-service consultation on the draft decision, where the relevant Directors Generals of the Commission are consulted on the content of the draft decision of the EEA decision, the EEA Joint Committee decision. The timeline on that can depend on the content of the decision, particularly if there are substantive adaptations. And I mentioned already, if there are substantive adaptations, those require also the Commission to inform and get consent from the Council. If there are comments from the relevant Directors General, then there might be kind of a back and forth between the EFTA states and the Commission on the content of the draft ACD, and sometimes there might even be a need for meetings to discuss that. But in most cases, this is a relatively straightforward process. Once the EU has agreed on a draft JCD on its part, you can start to prepare for the incorporation itself. And that is done, the EFTA Secretariat is responsible to drafting a list of all the draft Joint Committee decision that is ready for adoption. And then the Secretariat consults on this draft list, first with the EFTA states, and then with the Commission, to prepare basically the agenda for the next meeting of the EEA Joint Committee. The EEA Joint Committee usually meets around 8 times per year. It is the kind of the main decision-making organ for the EEA agreement, and is a forum for the EU side and the EFTA states to exchange views and take decision, always by consensus, to incorporate EU acts into the agreement, and thus making EU law part of the EEA law. The final step, well, before I say that, important to note that, and this is an issue that has already come up in the seminar, the entry into force, most of the case, the decision will enter into force the day after the adoption, but it's always for the Joint Committee to decide when it wants the decision to be adopted. But there is a very important caveat to that. The EFTA states have a right under the agreement to have a constitutional requirement to a decision. If they do so and voice that in the Joint Committee, it means that the decision cannot enter into force unless that the EFTA state has notified that it has fulfilled its constitutional requirement. What does that mean? It usually means that to properly be able to implement the legal act that's been incorporated, they need to make amendments to the national legislation, which means that they will have to get a parliamentary approval and also make the necessary amendments to the national laws. And they are not able to notify fulfillment of constitutional requirements until they have gone through the required parliamentary procedure. This is an example of decision of the EEA Joint Committee. Finally, once that decision has entered into force, the EFTA states are obliged to implement an act that has been incorporated. Under the agreement, we have a two-pillar system where there are EFTA institutions that are responsible for monitoring that the EFTA states are basically implementing correctly acts that have been made part of the agreement. And that are the EFTA Surveillance Authority, and there is a representative from the EFTA Surveillance have a presentation in the afternoon. And then we have the EFTA Court. Unfortunately, they are not here today, but any potential disagreement on whether an EU act that's been incorporated into the EU agreement has been properly implemented by an EFTA state fall under the jurisdiction of the EFTA Court. With that, I think I will leave it at that, and I hope that I managed to kind of go through it relatively quickly.